Speaking of monopolies, it gets us to our next story, which, of course, late yesterday, Microsoft's deal to acquire.
I have a wrap on that you'll love.
Activision.
So go ahead.
I'm going to go through a few things here because I do want people to understand sort of what really is going on in the playing field, particularly from an investor perspective. But, of course, as you probably are aware, the FTC taking action to stop that deal in a complaint filed with an administrative law judge. And we'll get to that in a minute because it is a bit different, although it is not necessarily of great importance. A few things to share here. In speaking to as many people as I could about the complaint itself, most are unimpressed with the arguments being made in the complaint by the government at this point. There's no economic data to support their contention. There's no economic analysis. It's Microsoft may do that, or they could do this. No real supportive proof or evidence at this point. Doesn't mean the government won't come up with some, but at this point, many, at least who've read this complaint, are unimpressed, let's call it, and don't believe the FTC will win. As a result, they define, for example, a high-end market, a high-end gaming market. They leave Nintendo out. They just said, okay, it's just PlayStation and Xbox in this high-end gaming market. But there are many different components of, or the lack of argument, at least cited by those who are students of these things. Again, these can go over time. Yes.
I'm a student.
Yes.
Okay. I know that there's something called Tied House Rules, federal law. 1934, coming out of the Depression. A liquor company cannot own a restaurant because it would favor that restaurant. So the doctrine here is that a software company, Microsoft, that makes Xbox, cannot own the liquor, the so-called restaurant. They can't do it because they'll favor that restaurant. They'll favor their own restaurant.
The vertical integration as opposed to horizontal.
Now, this is still the law of the land, as insane as it is, but the federal government has at times said, look, you can't own both because you'll favor your own product over someone else.
Well, that is the argument being made here is exactly that, except that, of course, we also know Microsoft has reached out, for example, to Nintendo with a 10-year deal. They've been willing to offer the same thing to Sony.
Wait, so what's this?
Sony has been by far the single largest critic of the deal, and they were offered that same 10-year for Call of Duty. They're not interested. Perhaps they want it in perpetuity. But again, let me get to the second point here, because while we will talk a lot about this complaint, and administrative law judge right now, by the way, Microsoft and Activision can close their deal. An administrative law judge does not have the power to actually enjoin the transaction. So they could close the deal prior to any hearing scheduled for August 2nd.
Go ahead, say it.
But this is going to go at some point to a federal district court where they're going to try and seek an injunction, the government. But let me back up a bit before that and talk about what is cited as the single most important impediment to a potential transaction. And it's not the FTC. It is the UK. It is the CMA, their antitrust authority. That is where the focus is right now. That is where you will find people with the most questions.
Okay.
Here's a J.P. Morgan note this morning. We think the UK CMA is the biggest risk given their traditional opposition to behavioral remedies, and it's more difficult to appeal a UK CMA decision. We're going to get a sense from the CMA, I think, let's call it towards the end of January, in terms of their Phase 2 findings. That should give us a real sense as to how they're coming out on the transaction. Not a lot at this point to really go on. They look at things different than we do in terms of their antitrust laws, opposed to what we look at. You can do a quick appeal, but as you just heard me read from J.P. Morgan, and it is true, there's a harder burden of proof there. So that is right now where at least the investment community is most focused in terms of a true impediment to this deal. Not this case, at least we've got from the FTC. Not, by the way, the prospect of the EU, which most believe will maybe there'll be some remedies, but we'll say yes. And not even SAMR, the antitrust authority in China. It is the UK's CMA. Finally, Jim, let me just end on my points here that were this deal to break for whatever reason, perhaps opposition from the CMA, perhaps you get to July 18th and Bobby Kotick says, I'm not going to extend our merger agreement beyond the termination date. I'm going to take my $3 billion in reverse break and my break fee. I'm going to have the cash that I have on hand, and I'm going to go back to running this company. There are those who believe the downside here is fairly limited for Activision shares. Now, by the way, we'll see, because we've heard that argument many times in the past. And then often when a deal actually does collapse, you'll see the potential acquirer stock go down fairly significantly. Why do they believe that, though? $4.65 in EPS next year. You put an EA multiple on that and add back in what could be as much as $13 a share in cash if you add in the $3 billion termination fee. And they simply say, hey, you can get to a stock price that says at least 70, if not more. So that's where a lot of the investment community stands right now. We've got a lot more to go here. Obviously, I don't want to make light of the government's action here, but many don't take it that seriously given the lack of strength of the case that they've read in those 30-plus pages.